application for leave to appeal the court's records. Lord, might I at the outset also simply state I don't intend to go through the application for leave. We try to make it as complete as possible. I'm only going to summarize a very brief argument. The legal principles applicable to an application of this sort are trite. All that the accused need to do at this stage is to convince your Lordship that there is a reasonable prospect that a court of appeal may come to a different conclusion. Now, my Lord, it's common cause that what we have here is an...
I understand your appeal is both against conviction and sentence.
And sentence. And may I also, perhaps while your Lordship is dealing with that...
But...
on the last paragraph 21.2 of the application against the sentence, that's my last alternative argument. I'm abandoning that ground.
Which one?
21.2, and that is in the alternative, if a court of appeal confirms the convictions and confirms that mandatory life sentences are applicable, I'm no longer going to proceed with an application that there's a reasonable prospect of a court of appeal under those circumstances interfering with the sentence. So I'm abandoning paragraph 21.2, the ground of appeal there.
Now, what does 21.1 mean?
Lord, we are saying that, and that goes hand in hand with the ground of appeal in paragraph 20. We're saying there is a reasonable prospect of the court, even if the court confirms the guilty findings on counts 1 to 3, that there is a reasonable prospect that the court of appeal may find that the state failed to prove beyond reasonable doubt that the applicant planned the murders or that the murders were premeditated. Now, of course, on that premise, in that event, the chances obviously will be, if a court of appeal agrees with us on that aspect, that the mandatory life sentences fall away, and the court will then consider, will be free to consider afresh a sentence without the provisions of section 51(1) of the Criminal Law Amendment Act being applicable. But if I may just, Lord, just briefly deal with my application itself, it is of course common cause that we are faced with a situation where a very young person is facing spending effectively the rest of his life in jail based only on circumstantial evidence. And our argument is that if one applies the two rules...
The only evidence against an accused is circumstantial evidence.
I'm sorry, my Lord?
In most cases, criminal cases, the only evidence against an accused...
It's different. Sometimes you do have direct evidence, for example, eyewitness and so on. All I'm saying, this is circumstantial evidence. We are saying, if one applies the two rules of logic as laid down by Rex versus Blom, the old appellate division matter, we are saying, first of all, that the inference drawn must be consistent.
I understand you're not, I've read your heads here, I read this notice. You're not relying any irregularity. What you're saying is that the onus was not discharged.
Well, my Lord, if I may just quickly develop, I'll try and summarize. I'm not going to go through it. I really will not waste the court's time. If I may be allowed to just to develop my argument shortly. We are saying that there's a reasonable prospect that the court of appeal may come to a different conclusion regarding the proven facts, either by making different factual findings that the Lordship, that this court has made, along the lines as we've set out in the application, or by the Court of Appeal attaching more weight to, amongst others, the concessions made by state witnesses during cross-examination. And secondly, we are saying, my Lord, that there's a reasonable prospect that the inference, in other words, that the accused's guilt follows beyond reasonable doubt, and that excludes any other reasonable inference. We are submitting that there's a reasonable prospect that the Court of Appeal will find that the accused's guilt beyond reasonable doubt is not the only reasonable inference to be drawn from the facts. Now, Your Lordship, in paragraph...
Those are factual findings which you...
Absolutely, but those are
You're
the grounds.
challenging the factual findings.
I'm challenging some of the factual findings, Lord, as set out in the application for leave.
You're not relying on any special circumstances or any irregularity as such.
I'm not sure what Your Lordship means by irregularities.
You're not relying on any irregularity in the trial proceedings.
Lord, if there was a irregularity, I would have applied for a special entry, and I didn't do so. My Lord, if one has regard to paragraph 758 of the court's judgment, where Your Lordship, in the preceding paragraphs, dealt with 11 different heads.
I'm trying to help you.
I'm sorry, Lord.
I'm trying to help you.
My Lord, I would really assist.
Are you saying that I misdirected myself? If so, how and why?
Well, my Lord, we are saying that on the facts.
Give me vague details. Specifically, what you said.
Well, my Lord,
what did I do wrong?
I will come to that.
Which will result in another court coming to a different conclusion.
I will deal with that. If Your Lordship will give me an opportunity, I will do so. In paragraph 758 of the judgment, Your Lordship remarked as follows in the first sentence: each piece of evidence on its own might not be enough to establish the guilt of the accused. Now, up to that point, I agree with Your Lordship. Yes.
That's not my law, that's the law that's been set down in this court.
But Your Lordship then said the cumulative effect of the pieces concludes the puzzle. We are saying it doesn't require a quantum leap to make out a compelling argument that even if those 11 grounds are taken together, that a court of appeal may find that the guilt of the accused is not the only reasonable inference based on the facts. Now, if Your Lordship invited me to deal with specific findings by Your Lordship, just by way of an example.
I read your head, so
yes. By way of an example, Your Lordship made a finding.
That simply means that this thing fits like a mosaic, pieces of a jigsaw puzzle. And if one comes to the conclusion, I did, everything fits together. If not, then this is left in the air.
Well, my Lord, Your Lordship invited me to point out where Your Lordship, for example, misdirected with regards to the facts. Just one example. Your Lordship made a finding that Mr. Uber found that the absence of Marli's blood from the axe was not inexplicable. Now, Mr. Uber in terms said, I can't explain it. Yeah. And later on when I put it to him, that's page 265 of the record, later on when I said to him that Mr. Sale said it's virtually impossible, and then he says, he agrees with Mr. Steyn. It's virtually impossible. Now, those aspects, my Lord, Your Lordship made different factual findings about that. I'm submitting, given those facts and those concessions, there must be a reasonable prospect that the Court of Appeal may attach more weight to those concessions made by the witnesses.
May not attach less weight to that fact. But does it mean it will come to a different conclusion?
Absolutely, well, it must be so. It must be so. Because if the factual basis on which Your Lordship made the findings, if I can deal then in a little bit more detail in paragraph 757 of the judgment in those sub-paragraphs, we are saying, my Lord, for example, that the Court of Appeal may attach far greater weight to the expert evidence of Mr. Rabi, which was not gainsaid, about the parameter fence and the alarm system, and that those were real alarm triggers that evening. The state did not gainsay that expert evidence. That evidence was not really attacked in great detail. That the Court of Appeal may, unlike the trial court, not rely as much on the hearsay evidence of Marsha Rousseau pertaining to the Thorburn property. That the Court of Appeal may, for example, also attach far more weight to the failure by the state to call a single person from Thorburn to testify.
Assuming you're right on everything you say, does it mean that another court would come to a different conclusion?
It must be then so, Lord, and that's not the only aspect that I'm dealing with. I'm dealing with a far greater detail with it. And I'm submitting, for example...
What about the fundamental pillars upon which the state's case rests?
Yes. Well, my Lord, those are one of the fundamental pillars which Your Lordship in fact found as well.
The fundamental pillars.
But Lordship
there
found
are other fundamental pillars upon which the state's case rests, which I see you've not dealt with in your application for leave to appeal. and which makes this case almost unassailable. One rarely gets a case so strong against an accused as in this instance.
But your lordship does indicate to me which one of the pillars that are not dealt with.
The self-inflicted injuries.
But Lord, grant. For the well,
You
we
can't
do.
say-
No
you see-
respect, we do deal with it in my grants.
Yeah.
We deal extensively with that respect. First of all, and secondly, as your lordship with respect quite rightly pointed out, that viewed in isolation is not enough. Your lordship made that finding.
That's correct, but that's a key aspect of this case.
Of course, a key aspect. But of course, another key aspect, both those experts were at pains to say that only some of the injuries of my client,
Yes, so
they
what?
can say it consists of itself.
I don't understand that argument really.
Well,
If
he gives the
there
he
are
gives the only
injuries as
explanation
in
about
this
the others.
case, Mr. Botha, the injuries in this case are classic self-inflicted injuries. Now,
not all of them.
assuming there are
No,
other
with respect.
injuries which we can't explain,
No, but
we
with
weren't
respect,
there.
That was not the finding of Tiemensma or Professor Dempers. They said some of his injuries, the one on the arm,
Yes,
3 on the arm and the 2 on the scratch on the chest, those are consistent with self-inflicted.
that's right.
Yes.
But those are classic
Yes.
self-inflicted injuries.
But they did not venture and say, for example, the stab, the 50 millimeter deep stab on the side of my client. That is consistent. Now, my client gives the version for that.
Now, Mr. Botha, in the
Where else did it come from? The state didn't provide the version.
in the realm of ordinary human experience, there were 3 murders, of attempted 4th murder. There was a scuffle. How can one decide how and what circumstances each of the other injuries were sustained? The only person who could say that is the accused.
Yes, and he did so, my lord, with respect. And again,
But his version must be capable of fair-minded support.
yes, but your lordship, again,
And
it's one of the
if
grounds
his
we
version
say.
is not capable of fair-minded support, then what?
No, with respect, Lord, it's one of the grounds we addressed there. We're saying that the discrepancies that that the trial court pointed out, first of all, we submit with respect not material. Secondly, that insofar as there were the discrepancies between the statement, Exhibit SS, that he made to the police later the afternoon, that there's a reasonable prospect that the Court of Appeal may have attached greater weight to the evidence of Dr. Butler about my client being under a post-ictal state when he deposed that affidavit.
Post-ictal state may have occurred afterwards. But
No,
with the
no, no.
self-inflicted injuries, he wasn't in the post-ictal
No, but
state
with
then.
respect, Lord, we're dealing with your lordship invited me to deal with his statement, with his discrepancies. I'm dealing with his statement that he deposed to. But my client's version, in essence, in fact, my learned colleague was at pains to point it out to him repeatedly during his cross-examination. My client's version from that morning until the day he finished testifying, in essence, remained the same. In essence, it has remained the same. And my lord, your lordship will no doubt be very much aware of that it's strike law as well. That your lordship don't even need, or the Court of Appeal don't even need to believe my client. The only question is his version reasonably possibly true? And we submit there's a number of aspects. For example, the blood spatter, 90 on his pants, another 17 on the socks,
It's not-
and
it's
somehow
not- it's
he
not
gets
for
it
the
right. He gets
Court
it
of
right.
Appeal to decide, it's for us to decide here, for this court to decide whether it's reasonably possibly true.
Absolutely.
The court will only interfere if there's an irregularity.
No, with respect, my lord. If it's a factual finding and the Court of Appeal
It
does not
differs
agree
with-
with your lordship, then they can interfere. It doesn't have to be a
But
regularity.
the
with respect.
impressions, the credibility findings of the findings of this court.
Sure, but again, my lord, there's ample case law that the Court of Appeal, in fact, there's case law from the SCA indicating that at times the court dealing with the record sometimes is even in a better situation to deal with. Your lordship did not make findings about the demeanor of my client, for example, in the witness box. Your lordship made findings purely, he said this, and there's discrepancy about that. And that the Court of Appeal can deal with as effectively. But we're coming back to the issue about the blood
I'll
stains.
interrupt you one more time.
I'm sorry, my lord.
I'll only interrupt you one more time, then I'll hear you out.
My lord, if the day that happens, I will probably fall down with surprise. My lord, if on as regard to the blood stains on my client's shorts, 90 of them, 17 on his socks. From the word go, he says, I'm in close proximity where my brother and my father was attacked. I wasn't close to where my mother and my sister were attacked. Now, he was either the luckiest man in the entire world that he knew that from the word go, or he's telling you the truth. And it must be a reasonable possibility on his version. Even if we just look at that. Even one disregard to that. In other words, that the blood stain evidence, in fact, does not contradict my client's version. It corroborates his version. Those aspects, I would submit, Lord, that on a court of appeal may attach greater weight to that and find that there's a reasonable prospect that his version is reasonably possibly true. Lord, and then, if I can move on, with regards to the sentence I've already addressed, Lord, so I'm not going to revisit that.
With regard to sentence, I mean, a life sentence, especially 3 times over, is a very severe sentence. And your client is a very young man. I mean, surely, if there's any doubt about that, they'll not grant you leave. But I asked you several times to advance any reason in mitigation. Besides the age and previous convictions, or lack thereof, there's nothing you could say. I was asking you to give me a peg on which to hang my coat.
Lord,
you gave me no peg.
Yes.
I was faced with a situation where there was no real evidence in mitigation placed before me.
I don't understand this with great difference in your Lordship. What your Lordship wanted from me, from a client who says, I'm not guilty.
No, I didn't want you to say that, but
what else can I give you, Lordship, then?
In any evidence which could have ameliorated the sentence. The simple age is young and has no previous.
Well, I presented before your Lordship a report, and I assume your Lordship had regard to that as well from the social worker.
The social worker, yeah, yes. That's about.
I couldn't take it further than that. Was I can't say remorse. I can't say anything else because my client says I didn't do it. In fact, if my client had changed tact at that stage, I probably would have to withdraw from the matter. That was the position I found myself in. So I hear what your Lordship is saying, and I would have loved to have given your Lordship more than what I did. But that's all I could give under the circumstances. Those are my instructions. I can't go beyond that. Those are my instructions under these circumstances. But I'm saying on the sentence, if your Lordship is with me, there's a reasonable prospect.
Life sentence is a very, we give life sentences far too freely nowadays. In South Africa's 10% of its prison population are serving life sentences now. And that's unacceptable. But when a case like this presents itself, what option do I have?
Well, look,
you know?
That's what I'm saying. And for example, with respect, I've already abandoned the last ground. I'm with your Lordship. My argument is the following. The only evidence that the state profit on which the peg, if I use the phrase your Lordship has referred to, which to hang beyond reasonable doubt that the murders were premeditated or planned, was the finding that the axe had to go, somebody had to go fetch the axe. Now, on the case with respect that I have at regard to, with respect, there is a very real possibility that the Court of Appeal may find that's not enough. That's not the only inference that was premeditated or planned.
Aren't you looking at this rather rose-colored spectacles, Mr. Botha?
Either with me on that and say there's reasonable possibility of success or not. But the case law on that aspect is clear and unequivocal about it. In fact, there's a number of aspects where a person walked back to his house for 300 meters to go fetch a weapon and then killed somebody, and it was found it's not premeditated. Now here, the only person, even my lordship, if the lordship finding stands that my client was to fetch the axe, I'm submitting that in those circumstances there must be a reasonable prospect.
How come the axe, which is normally in the kitchen,
the lordship indicated lordship will give you an opportunity to address your lordship.
Okay, yeah. I got the motion roll to attend to still.
I'm trying to get through this as fast as I can. My lord, under those circumstances, I would submit that there is a reasonable prospect that the Court of Appeal could find that it's not the only inference in law that it was premeditated or planned, and then it follows from that the prescribed minimum sentence of life is no longer applicable. It's only 15 years then, and given my client's age and fact that he's first offender, a court of appeal may then find that life is not necessarily the only appropriate sentence. And if I may lastly address your Lordship with regards to the court, should your Lordship be with me and grant leave, why the Supreme Court of Appeal, I would submit, I know of no other matter.
Can I ask you one? You see, the sentence would have been different if you had shown me somehow that this offence was committed, the product of a broken mind. But there was nothing of that sort before me. There's no medical evidence. There was no medical evidence before me to show that it was a disturbed individual. That would have made a big difference.
No, absolutely not. In fact, one of the grounds would be that we are dealing with on the merits. We're saying there's one of the aspects on the merits that is shouting for an answer from the state. And I know that the case law, your Lordship don't have the final motive, but what was his motive? As your Lordship had indicated, what was the motive of other people, unknown assailants? What was the motive of my client? All the evidence before your Lordship was this is a close-knit family, happy family, that evening there was no problems. And this murder, what was the motive? Under those circumstances, is there not perhaps reasonable prospect?
For the unknown intruder, what was the motive?
But that's the exact point. If your Lordship says, because your Lordship can't attach some kind of discernible motive to an unknown intruder, we are saying the chances are that the Supreme Court of Appeal may equally say, well, I can't attach any discernible motive to the accused doing this, so it makes it also at least reasonably possibly true that it wasn't him that attacked his family. On that reasoning. Lastly, my Lord, why the SCA? I need to address your Lordship shortly in that as well.
Which case is that?
I know of no other matter, and my learned colleague may point me if I'm and correct me if I'm wrong. I know of no other matter where so much was DNA evidence was led, so much blood stain evidence, and so much complex medical evidence was led. All circumstantial evidence which then requires the court to make a factual finding. And that in itself, I would submit, Lord, it is absolute crucial that the Supreme Court of Appeal also, in fact, if your Lordship is with me in grant leave, that the Supreme Court of Appeal is given the opportunity to deal with this matter. Because we need to know as practitioners, we need to know as courts, we need to know about these issues, about the DNA evidence, in what manner the forensic science laboratory should deal with those aspects. The blood stain evidence is the same. What weight should be attached to it? Because there has never been another matter like this in our legal history. Those are my submissions on behalf of my client. Thank you.
Thank you, Lord. I can both respondent. May I also apologize to the acting of Mr. Blas, who is currently on circuit court.
That's all.
May I then hand a signed copy of my head? It's a very short response to the application for leave to appeal, my Lord. I will not burden the court with the citation of section 17 of the Superior Courts Act.
This is not a question of sentence. So, can I take you in reverse order?
That's correct.
Do you understand what Mr. Botha is saying?
My Lord, as I understand his argument, he says the court erred in finding that the murders, counts 1 to 3, were committed with premeditation, and as such, the provisions of Act 105/1997 is not applicable, and thus not a minimum sentence of life in prison. But it's our argument that the court correctly found that it is applicable in the sense that even though there is case law that says it doesn't matter how long the decision or the premeditation is formed before the actual deed is committed. The mere fact that, as the accused found to be the attacker, that he had to go from upstairs, where they were all in their beds, downstairs into the scullery to fetch the axe and the knife from the door and kitchen, return upstairs and then attack his brother, not with dolus indirectus, but dolus directus, aiming for the head. There cannot be another inference than that it was premeditated. Our alternative argument is, even if that evidence is not enough to find premeditation for the purposes of the minimum sentence of that law, the facts and circumstances of the case is such that of course the Marli argument on sentence should always have been a matter where the most severe
Is whatever the legal, the statutory provisions, yeah.
Aspects cited by by counsel in the application for leave to appeal, with all due respect, my lord, it is the nitpicking of circumstantial evidence which causes Mr. Botha to rehash.
I didn't want to use that phrase, Ms. Callaway. I was being kind to your opponent.
He is again taking apart the circumstantial evidence, and then, as is remarked by the Supreme Court Appeal, Lord, is missing the wood for the trees. When one individualizes the evidence of circumstantial evidence, you might miss the mosaic of the picture that is created by the evidence. With regards to the DNA and the blood spatter evidence that Mr. Botha seems to argue that it's an important matter that needs to be decided on by the SCM Lord, the court correctly found at the end of the judgment that not much weight needs to be afforded to the DNA and the...
You can ignore the DNA altogether. We come to the same conclusion in this case. Yeah.
That is the objective circumstantial evidence that the court quotes in paragraph 757 of the court's judgment. It's objective, it's not related to the blood spatter or the DNA and evidence, my lord, and based on that, it is our argument, my lord, that the court correctly convicted the accused. The court's, all the credibility findings, if I may just in short answer on the argument of there would be no motive for the accused to do these murders, my lord, all was not as happy families as it would try to depict it. That might be what was shown to...
What do you think of the attack is Mr. Botha levelled against Ms. Opterhof in this notice of appeal?
My lord, again, he deals with what...
That's a totally innocent bystander.
Indeed, my lord. And it was never their case that you could not hear anything because nothing happened. They agreed indirectly that she might have heard something, but that what she heard was a track of a movie that they were watching. The time for that is totally inconsistent with what Ms. Opperdoff testified, and she was very clear and concise in the evidence that I heard people arguing. If she wanted to lie and make up a story, she could have very well expanded on the whole evidence and said, no, I heard Henri and his father and Rudi all arguing, and they were arguing about this and this. She does not. She says, I heard voices that sounded like an argument. My lord, with all due respect, clear evidence of a witness who is very objective and honest in her evidence, my lord. And the court's credibility finding on that, with due respect, is correct, which then means that the family, there might, or there is a possible motive.
That creates then the climate in which the later events occurred.
Indeed, my lord. That was
which makes sense. That's a mosaic that,
Indeed,
that the events that fit together.
Indeed. My lord, on those arguments then as set out in our heads, we are of the view that there is no merit on the application for leave to appeal, and the application on both the conviction and the sentence should be dismissed.
Mr. Botha, any further to add on the law?
Nothing further, thank you, my lord.
I think in fairness, it's a very important decision I made. In kindness and fairness to you, Mr. Botha, I'm going to read your notice of appeal again and come to a conclusion the next day or two, let's say Friday morning.
Court, please.
Hand down judgment on this aspect. Friday morning at 10 a.m. Sports agenda.